Good afternoon, everybody. My name is Trevor Farrow, and I'm the Dean of Osgoode Hall Law School. And I want to virtually welcome all of you to the Artificial Intelligence and the Law: New Challenges and Possibilities for Fundamental Human Rights and Security Conference here at Osgoode Hall Law School, hosted and put on by the Nathanson Center at Osgoode and York. So delighted that you are all with us today. I'd like to start acknowledging our presence on the traditional territory of many Indigenous nations. We recognize that the area known as Takaranto has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It's now home to many First Nation, Inuit, and Métis communities. We further acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. So we've got a packed conference, and we're going to get there shortly. I just have a couple of opening remarks with my colleagues. It won't be lost on anyone that this conference is bringing together experts on topics of critical importance to not only but society. The rapid advancements of AI technology are already reshaping our world in profound and unprecedented ways, from revolutioning industries to transforming the ways we live, work, and interact with each other. Clearly, the future of AI is already here. And without a doubt, AI is already driving progress and innovation in many different ways, in areas of health, transportation, engineering, security, etc. Of course, it's all around us. But as we'll explore, with opportunity comes risks and challenges, which can't be ignored. And today's conference brings together an impressive group of academics, lawyers, and government officials who will consider the development and deployment of AI and its impact in Canadian society, both in terms of the opportunities and in the challenges. Before I close, I do want to thank the Nathanson Center, Osgoode Hall Law School at York University, and in particular my colleagues, Professors Valerio De Stefano and Barnali Chowdhury, who have really been the driving force behind this conference. And a particular shout out to Valerio with his vision and determination has really propelled this discussion that will lead to the kind of collaborative and important dialogues that will follow and that provide us with really important thinking on the transformative potential at AI to build a healthier, more just society for all. And in particular, as we think about our interventions here at Osgoode, at York, and in our various communities. I also want to quickly recognize that these conferences are certainly not self-executing, and our colleague, thanks to our colleague, Lial Gonzalez, for her tireless efforts as well. So with that, I think Barnali and Valerio, I'll stop there. I know I'll be back later. Just very excited about this session. Congratulations and thank you. And over to you guys.
Thanks so much, Trevor. I'm just going to say a very brief welcome to everybody for joining us today. Thank you for all of you for participating in this great conference, despite the fact that this strike is going on and that you still joined us today. We're excited to have all of you from around the world joining us as well. We hope that that you will learn much from this and from the vision of my colleague, Valerio De Stefano. I also want to echo thanks to the Nathanson Center's organizing team, particularly Lial Gonzalez, who has done a lot of work for putting together this conference. Thanks also to Osgoode Hall for supporting this conference, as well as to Dean Farrell for being very supportive in making sure that the vision is put forward. And finally, a very, very special thanks to my dear colleague, Valerio De Stefano, who I'm going to pass the mic on too. This is really his vision that we are just participating in, and it is truly a pleasure, Valerio, to work with you every day. So I'll pass it on to Valerio.
Well, thank you so much, Bernali and Trevor, for these super kind words and introduction. And it has been a real pleasure to work with you all, with Osgood, with the Netherlands Center, and with the fantastic support of Liel Gonçalves to organize this event. And I'm very thankful to all the colleagues that will be joining us today for what will hopefully be a fantastic afternoon of discussion about very important topics. Before going there, I would just like to briefly mention that originally this conference was supposed to be hybrid and take place in person as well. There is at the moment a labor disruption at York University, and so we didn't want to ask people to interfere with the labor disruption and to cross picket lines. One thing you should know about labor lawyers, and I am a labor lawyer, is that we are not comfortable in crossing picket lines either. But I want to thank everyone for their flexibility in switching these online. And again, this is going to be a terrific discussion. The reason why we have put this together at the Netherlands Center and at Osgood, again, with the support of Professor Chuduri, Dean Farrow, Liel Gonçalves, and all the other colleagues here, is that we think that AI is going to play a momentous role in shaping, of course, our societies, but also our legal systems. And there is ways in which this is happening that are overhyped. In some cases, AI won't be probably for the next foreseeable future as groundbreaking as it is purported to be. And in some other cases, instead, we notice that technology and AI specifically is already changing our societies and our legal systems in ways that are not always easy to detect, and in some cases also posing new challenges that must be tackled by the law. So there is on the one hand, overhype around artificial intelligence. On the other hand, somehow some of the detrimental implication of AI are being somehow neglected. And also, we are not doing enough if you want to ripe the opportunities and benefits that can come from the use of AI, also in making our legal systems fairer, more just, and also more accessible, particularly to vulnerable people. The reason why we wanted to organize this at the Netherlands and at Osgood is because we could basically, if you want, piggyback on the fantastic expertise that sits around the Netherlands Center and Osgood. Many of our colleagues, most of which you will be hearing out from today, are engaged in groundbreaking research and scholarship around technology and the law, artificial intelligence and the law every day. So this is not just a one-shot event. It speaks to basically an effort that Osgood and the Netherlands have been putting together to be at the forefront of research and scholarship on artificial intelligence and the law. And this is why we could easily organize this by gathering all the experts in the same virtual room for one afternoon and try to give a sense of what is going on in various sectors of the law, based on our research and scholarship at Osgood and the Netherlands, but also calling other colleagues from outside the law school and the center, and we are also very grateful to them. With that, with no further ado, I will give the floor back to my colleague, Professor Barnali Chuduri. And again, I would like to thank her. She's the director of the Netherlands Center, and she has been instrumental, essential to make this thing happen. Thanks again to Dean Farrow and to Liel Gonçalves and to all the colleagues that are here with us today. And thanks for the audience to be with us and to be flexible and for switching so smoothly to the virtual scenario. Thanks again, and let's start the first session.
So great. On that, I think after that momentous talk by Valerio, I believe we could get started with our first panel. So our first panel is AI and the law, and we have a great group of panels that are going to be speaking on this issue. The bios for each of these individuals are already up on our website, so you can look at them there. So I won't be introducing everybody. Instead, I will just ask the speakers that if you stick to your time allocation, please, of 15 minutes, and I will be giving you a 1-minute warning when your time is nearly up. And we will begin with Alan Hutchinson, who will be speaking on reflections on singularity, AI, and law's multiplicity. Professor Hutchinson.
Hi, so first of all, I just want to make sure people can hear me and see me. Well, maybe hear me is better. So I'm assuming I can be heard.
You're good.
Good. Okay. So let me begin by saying I'm rather surprised that I'm actually speaking at an AI conference. I'm even more surprised, gobsmacked, at the idea that I'm opening at this. I never thought of myself as much of a techie. I'm not a technophobe, not a technophile, but I've tried to use the idea of next phase. If you miss out on the next phase, you'll never make the move when the next phase comes along. And so I've been dabbling with AI. One of the things that got me into this was I wrote a book about cryptocurrency, and that sort of introduced me to a wider technical world. And so I've done research on AI in my field, which is basically legal theory and jurisprudence. I get some criticism. People say, I think somewhat strangely, that this is a rather odd thing to do. Some people get close to saying it's a kind of cheating. I think that's silly. So others say it's not very rigorous. My view is it's as good a place to start as any, but it's not a good place to finish. And so that's my understanding of AI. I actually toyed with the idea of getting AI to generate my presentation today, but decided that would be a little too cute. So my expertise is around legal theory. And what I want to talk about today is to focus on the idea of AI and adjudication, particularly in the higher reaches of the courts. And in looking at AI, I want to use the measure of this. Say the strength of a good idea, a good practice, is twofold. One is its basic core insight. And it seems to me AI has many, many strengths and can be very valuable to the legal process. The second is, though, as well as its core insight, we need to recognize reasonable limits. We need to say this insight is important, but can it really apply to everything? And I want to challenge that idea and say AI has immense value for legal services, opening up legal services, at least the potential to open up legal services. I'm always skeptical that the legal profession will open up at any cost to themselves. But I want to look at here the idea of adjudication and what role AI can play and the recommendations by various people. And I want to concentrate upon a very recent and excellent book by our colleagues at U of T, Abdi Edid and Benjamin Alari, called The Legal Singularity: How Artificial Intelligence Can Make Law Radically Better. But before I look at what they say, I want to step back and say and rely upon a trope that was introduced initially by Herbert Hart, drawing from literary sources, about the nightmare and the noble dream. Understanding, trying to come to grips with what adjudicators do. He says we're caught a little between the nightmare, the judges make it up as they go along and basically objectify their own personal values, and the noble dream, which says the law is certain, and if you look deep enough, there's an answer to everything, and not only an answer, but a right answer. That's obviously associated with someone like Ronald Dworkin. Hart, of course, says all he wanted to do was get a good night's sleep. And I think that's a nice little stand to take. So I want to suggest when we look at AI and the recommendations for adjudication, that there's a spectre haunting AI and adjudication, and that spectre is formalism. Formalism is the idea that there's a fixed, stable, complete, and predictable body. And a word that we can use nicely to go with formalism that resonates with AI, of course, is algorithmic. The idea that law can be reduced in some ways to an algorithm. And I want to challenge that and think about that and what it means. And to do that, as I said, I want to look at the work of Abdi Aidid and Benjamin Allari. I think they cover the whole terrain of law. I think some of their recommendations, particularly in litigation, about expert reports, discovery, case management, are really interesting, exciting, and I think could fulfill a great purpose. But I want to concentrate just on what they're recommending about adjudication. And they combine, I think, a couple of things. It's a mix of a romanticism on their part, the noble dream, but also a certain hard-headed realism, which evokes something of the nightmare. That law's bad, but it can be salvaged by artificial intelligence. So their critique is quite simple. Laws are too complex, riddled with inconsistencies and internal contradictions, and ineffective in remedying many types of significant social injustices. So they're going to put on offer to us a whole system. And one of the ways that they say this is they initially offer some caution and modesty, but right up front they say, quote, a stable and complete legal order capable of addressing and resolving practically all types of legal uncertainty in real time and on demand is both the goal, the promise, and the possibility of AI. This strikes me, this idea that what we need is stability, complete, that is no gaps, legal order, and will resolve all types of legal uncertainty, is to me enticing, maybe seductive to some, but it's very problematic. And I think this is brought out in particular with one of their, what I think is over the top by any standards. They say, artificial intelligence will empower the judiciary with vast amounts of data and information, as well as practical objectivity. Judges of the distant future will approach achieving what the ancient Egyptian viziers could only imagine, the omniscience and impartiality afforded to the divine. Now that's quite a statement, and it's a statement that I want to suggest is inappropriate as regards adjudication, and most importantly, in a sense, not helpful. They base this idea on a very narrow view of what law is, particularly when they think about the common law. They talk about law as evolving, developing incrementally, with some identifiable continuity. There's path dependency to the law, stare decisis, and it's all precedent/data driven. This is a nice setup for their own idea of how an algorithmic approach can work. Most of my work has suggested that although we pretend that law is evolving and developing incrementally, there are pathways, there's continuity, most people who really look closely at law will see that it doesn't really fit that idea at all. Law is constantly taking left turns, right turns, U-turns. We're never sure where it is. Legal theorists are very good at looking back and suggesting there's actually a pattern, when in fact we have no idea where law is going, either in the next week or in the next year. And I think this underpins and is problematic, because I see law as a much more chaotic and politically driven process. I've been teaching constitutional law, the charter, this term, and I can certainly report that reading Supreme Court decisions, I find it hard to believe that the law is somehow certain or has any capacity to be certain. So this idea pushed forward by Ayadid and Alari is that what we can do is we can now put all these cases and precedents into the system. And more than that, we can overcome bias, both cognitive bias, but also personal values. So we can strip out law, and then we can be fully confident that this kind of scientific and also algorithmic approach will deliver the kind of legal system that we want and that will benefit, in their words, a democracy. Needless to say, this idea of what they think is a good legal system, I think is problematic, and that a total reliance on AI would be very problematic indeed. In a sense, certainty and getting it right are not the main ideas. I think other values can be and are more important than truth-finding and accuracy and predictability. The word that seems missing from most of their discussion is the word, of course, justice. But what we're looking for, presumably, as much as we find it hard to find it, is justice among people, between people and government. And they have a confidence, which I do not share, that AI can deliver this. In fact, as they say, they think of judges becoming omniscient and impartial and with a touch of the divine. So for me, the legal system, one of its important values, which it doesn't always live up to, is the idea that we should craft and create justice for ourselves. It need not be delivered by an algorithm. I'm not averse to the algorithm. I think as a support device and resource, I think AI can be very valuable to judges. But the idea it will take over the adjudicative process, particularly at the upper end of the court system, is to me rather frightening. What we want, presumably, if we are to advance both justice and democratic participation, is we need to recognize that we have to create justice for ourselves as a people and not receive it as a gift, whether that gift comes from so-called experts who are passed off as judges, or even more so, judges armed with AI, I think is something that we should guard against. And I don't want to sound incredibly conservative in this, but I want to emphasize, I think AI has its place. But one of the terms that keeps jangling in my head is something from exactly 100 years ago in 1924, when John Dewey talked about slot machine jurisprudence. And there's a frightening sense, a shadow that's cast by that. Certainly, AI is much more sophisticated than the kind of slot machine that Dewey had in mind in 1924. But it also reiterates, I think, something even earlier by one of the most quotable of all legal theorists, which is Oliver Wendell Holmes, Jr., who said, end of the 19th century, the logical method and form flatter that longing for certainty and for repose, which is in every human mind. But certainty generally is an illusion. And I think that really says a great deal about the ambition and the project that's being put forward, that AI can solve all our problems. It can deliver justice. I think it has a role in providing some certainty, predictability, and a certain accessibility. But to imagine that AI can take over and deliver what we want is problematic, both in terms of form and substance. People need to be involved in controlling their own lives. And in some ways, AI presents both a great possibility, but also a great threat to democracy. People already feel isolated and outside the system. I'm not entirely clear that this will be as helpful as many optimistic AI people think. So let me end. I don't defend or idealize law's incompleteness, uncertainty, and indeterminacy. In fact, much of my work is devoted to exposing that. But I think it's fantastical to think that this can all be corrected and improved by AI. Just to go back to Herbert Hart, he said both the nightmare in some sense and the noble dream rely upon a rationalist superstition. Each of them have these illusions have some value in teaching us what we should be doing in thinking and making law, but they do not have nor represent the solution. My last line is, AI can and should contribute and serve the cause of justice in the courts, but it should not control and take over. Thank you. And I think I'm inside my 15, yes.
Yes, thank you very much for staying on time, Professor Hutchinson. Okay, so up next is Professor John Penny, who will be talking about how safe are AI safety standards. So John, you've got the floor.
Great. Let me just share my screen here. All right. Can everyone see the slides? And let me just ask, can you
Looks
now
good.
and can you now see, did they change? Sometimes this happens with Zoom, they don't change. All
That
good?
seems to be working.
Great. Thanks, Grant. All right. So first of all, let me say it's great to be here virtually to be part of such a fantastic event put together by another great event put together by Barnali Valerio and Liel and the Nathanson Center. So thanks so much for the opportunity to present this work. And I should also say, following Hutch, I think he's a bit too modest about his knowledge of technology. I've sat on discussion panels with him on cryptocurrencies, so he's a bit modest, I think, in terms of his tech. So it's great to follow his skepticism about AI and the law. And you're going to get another dose of skepticism from my presentation and thinking through some of the new standards in relation to AI systems, safety standards in particular. So where I want people to begin is just imagine a world. So imagine a world where the toaster that you used this morning to toast your bread, rather than being tested by independent testing organizations to conform to safety standards for appliances like the toaster, the company that manufactured your toaster and sold it to you simply declared that your toaster was safe. Would you trust it not to one morning catch fire and burn down your place? In fact, when we look at the history of capitalism, 19th century, 20th century, certainly through the 20th century, it's riddled with examples where if we leave product safety and product safety standards to industry, the result is disaster. Whether we're talking about food additives and food adulteration, like the sweetener mass poisoning of 1838 in Bradford, England, which led to some of the first food and safety ordinances in England. Or when we move to the 20th century, we're talking about drug treatment, both early 20th century and later in the 20th century. And of course, let's not forget the automobile, like the Corvair here, which was one of the most popular designs sold by Chevrolet in the 1960s and often marketed to families, like this advertisement that you see here, that Ralph Nader in his 1965 book demonstrated were unsafe at any speed. And so clearly, when it comes to technologies and it comes to product safety, industry, at least the history shows us, it's really difficult to trust. And today we're talking about AI systems, which in ways are going to be far more ubiquitous and far-reaching in their impact in all areas of society than many of those products themselves. And so naturally, we need to be thinking about AI standards. Now, there's not a day that goes past where we likely don't hear or read in the news about another fatal accident involving decision assistance or driver assistance technologies like those developed by Tesla. And in fact, if you look at the data, and this is from the Washington Post reporting on point, looking at some of the driver assistance technologies developed by Tesla with their driverless vehicles like autopilot and full self-driving, it's over time, the number of accidents and fatalities are actually increasing and not decreasing as these systems are used more and more on the road. And in fact, for those who are wondering, yes, these very systems are being autopiloted under regulation enacted by Ontario on the streets of Toronto today. But it's not just that kind of road safety at stake when it comes to AI systems. There are also clear concerns about privacy, as demonstrated by the Clearview AI facial recognition technology story, combining facial recognition technology and surveillance and law enforcement powers. There's, of course, concerns about the security of AI systems. Here's an example where some researchers were able to simply modify a stop sign in some very simple ways by changing, just adding a few stickers to a stop sign. The same way as if you had some mud splash on the stop sign, which caused a driverless vehicle, a Tesla, to careen off the road and into the ditch. And even beyond these concrete safety concerns are broader ones, right? About broader harms in society, impacts on the economy, impacts of automation on work and labor. So naturally, when it comes to safety and concerns, AI matters, but it also matters to life and death today. Here is an example of a safety mechanism that's designed into Tesla's driver assistance technologies, both autopilot and full self-driving, where the system is malfunctioning, for example, and it alerts the driver to take over control of the vehicle. What research has shown is that it takes a driver an average of 17 seconds to take over control of the vehicle after being alerted by an alert system just like this. On the road, as we all can imagine, that's a matter of life and death. But not just in the driverless car or the driver assistance technology context on the road. When we move to AI in healthcare, where there is great promise for medical diagnosis, care management, and early cancer detection, there's also clear evidence that AI systems make important errors. And often the doctors that are using the technologies have no way of understanding when the system has made an error. It only becomes apparent later when the diagnosis goes awry. So there are biases in the system, but not just that. In practice, there's studies that show that often these systems providing alerts to doctors, there's so many alerts that these AI systems are providing to doctors as they're working in emergency rooms and in medical rooms. The doctors in practice start ignoring the alerts over time. Right? So those are examples of where safety standards are defective and they matter for life and death. So AI safety matters. So naturally, we should be thinking about the new AI safety standards and regulatory proposals that are out there. And there are a number of them being developed today. There's NIST AI standards, which will govern in the United States. There's the EU AI Artificial Intelligence Act that's has the most comprehensive scheme out there, including standards and their enforcement. Canada, we're undergoing our own regulatory reforms with the Artificial Intelligence and Data Act, as well as the Standards Council of Canada is right now drafting new standards themselves. I'm going to focus on the EU AI Act, and I'm going to make an argument that all of these standards are too vague and uncertain. They have contradictory requirements requiring trade-offs. And there are serious issues with both testing and enforcement. And as I mentioned, I'm going to focus on the AI Act. And the reason being is it's the most robust and comprehensive scheme anywhere. And it's likely, like the GDPR, the General Data Protection Regulation before it, where there was a Brussels effect, it became, because it was the most robust standard, became in ways a global standard for data protection legislation, the AI Act also has that likelihood. And if there are problems with the Act being the most comprehensive and robust, then we really have a problem. So let's take a look at how certain and the nature of the standards themselves. Let's return to that toaster. If you flipped over your toaster, this is likely what you're going to see. Right? You're going to see an indication, there's going to be reference of Intertech, but also mentioning of certain standards. If you look closely, you may not be able to see, but I'll read it out. The indication here is this toaster conforms to UL standard 1026, that's Underwriter Laboratories standard 1066. It's also certified to Canadian Safety Standards CSA standard C22.2, as well as number 1335.1, 1335.2.9. So there's a number of different standards that this product conforms to. And Intertech, and I'll mention Intertech a little bit later, the standards organization in question. If you take a look at those standards, what do they actually mean and what do they actually mean? So UL standard 1026, International Safety Standards for appliance voltage, 126 pages long. CSA 22.2, Canadian Electrical Code Standard, 80 pages long. CSA 1335.1 and 1335.2.9, Safety Standards for Household Electrical Appliances, 202 pages long. And there are other relevant safety and efficacy standards to the Canadian toasters I've mentioned on the bottom line there. If you take a look at the EU's AI Act, which, let me remind everyone, is the most robust and comprehensive standard out there in terms of standards and their enforcement anywhere in the world. All of the standards are set out in Chapter 2 of the Act, and they are 6 pages long. And even when you look at the standards themselves, they're highly qualified and hopelessly vague. So let's look at Article 13 as an example. Article 13 mandates transparency about, quote, input data for high-risk AI systems, but that requirement is qualified as applicable only, quote, where appropriate. Where appropriate. Article 14 mandates that, quote, human oversight must be built into high-risk AI systems, but only when, quote, technically feasible. So you can see, even with these incredibly brief and abbreviated standards, what's specified here leaves so much vagueness, uncertainty, and leeway to designers and industry in making design choices. It's hard to say you'd look at these and be confident in any of these safety standards. But what about the nature of the requirements themselves? They also require key trade-offs as well, and that has implications for safety. Let me explain. So if you take a look at some of the requirements that are set out in Chapter 2, often they have key conflicts or contradictions in what they're mandating designers to do in the AI systems themselves. Let me give you an example. In Article 15, it requires high-risk AI systems to be designed to achieve a, quote, appropriate level of accuracy, robustness, and cybersecurity in light of their, quote, intended purpose. But it also requires that they are designed to ensure that any, quote, possibly biased outputs are duly addressed. Okay, that sounds great. You're designing according to those standards, sounds like it could be robust. You'd have something that's accurate, robust, secure, but also less biased and fair. But let me zero in on just 2 of those requirements: robustness and biases. The nature of AI system design today is that as you make your system more secure and more robust to adversarial attack or easily trickery or easily hacking, the less accurate and more biased your system outputs are going to be. So Article 15 is actually mandating safety standards that will require a trade-off. And as we've seen again and again, when you look at AI systems like Amazon's famously clunky and badly designed facial analysis technology, which was very accurate on lighter skinned faces, but really inaccurate when it came to the faces of visible minorities. These companies are concerned about accuracy and biases. And so there's going to be clearly an incentive towards accuracy, which means less safety and less security, depending, of course, on the context. In other contexts, they'll favor security, and what we'll end up with maybe bias, in this case, racially biased and disturbing outcomes. But that's not just all. There are serious testing and enforcement issues as well. Let's go back to that toaster. And let me just highlight the standard organization that's referenced here. There's a few that's referenced. You have Intertech, you have UL Labs, which historically was Underwriters Laboratories, and the Canadian Standards Association. All three are independent standards and testing organizations out there. Do we have the same kind of requirements when it comes to AI systems under the AI Act? Well, here's how compliance and enforcement works under the AI Act. You've got pre-market conformity assessments. That is, they've got to have conformity, but it only applies to high-risk AI systems. That is to say, systems that pose a high risk of harm to people's health, safety, and fundamental rights. The vast majority of AI systems are not actually assessed. But most importantly, there is a huge loophole that firms can simply declare that their high-risk AI systems conform to the Act without any kind of independent third-party testing or audits. So naturally, in light of these problems, my conclusion is AI safety standards are just not safe at all. So let me just conclude with one slide. I see I'm out of time. Naturally, we need to have far more robust enforcement, much more specific standards, mandated transparency, as well as robust certification and enforcement. And we're in the middle of important reforms in Canada right now. And I hope that the government of Canada in the reforms under the Artificial Intelligence and Data Act do all of these things. And I'll finish there. Thanks.
Thank you very much, John. I'm going to go back now and look at my toaster to see what kind of safety standards it meets. But while I do that, we'll ask our next speaker, Professor Karis Craig, who will be speaking on the AI copyright trap. Karis, you have the floor.
Thank you. Let me check that this is up and running. Okay, so thank you, first of all, to Valerio and Bernali for bringing us together today. It really is a wonderful occasion to hear from colleagues who are all working on artificial intelligence. And while it's a shame that we're online and not together, it's terrific to be able to do this. So it does indeed seem that the age of AI has arrived. Rather than the conquerors of our sci-fi imaginings, these intelligent machines have actually come to us as creators. Okay, and that's because today's generative AI is trained, of course, on millions or billions of existing human-created texts and images, but is capable of generating new works, new texts, images, music, software, and more, all of which have the sort of external hallmarks, at least, of human creative expression, making them really virtually indistinguishable on their face, at least, from works of human authorship. So the go-to examples here are now, they might have been surprising a year or two ago, but now they're all pretty familiar. You know that with a few basic text prompts, Chat GPT can spit out prose that fulfills all the demands of almost any writing task you can imagine, that can fool the most discerning reader into believing that the words were uttered by another person, not constructed by algorithmic code. Trained on massive data sets of images and textual descriptions, Midjourney can do the same with visual arts. Uber AI can do the same with music. The Sora app, which was recently released, can turn text prompts into striking videos in the blink of an eye. So as the late Dan Burke observed, we have entered now an age of mass synthetic creativity. And it's hardly surprising then that copyright law, which of course is the law that allocates rights over original works of literature and software and music and art and drama and film to encourage their creation, that copyright law has been launched into this fresh sort of existential crisis, the likes of which really we haven't seen since the arrival of the World Wide Web and Napster. Now, it seems like some people are predicting that AI will be the death of copyright, as we predicted about Napster too. Others imagine that copyright will spell the death of AI. And certainly both things could be true, but it seems more likely to me that neither is actually going to come to pass, right? But in the meantime, we really shouldn't underestimate the damage that each could wreak upon the other. So rather than getting into the weeds on copyright doctrine and how it applies to AI, for our purposes today, what I want to present is an essay that's forthcoming in the Chicago Kent Law Review called The AI Copyright Trap. And it's tackling things at a more abstract level, just something that was beginning to weigh on me listening to sort of the political discourse around AI. I think we're increasingly hearing the critique that AI is extractive, that it's exploitative, and that it relies upon the consumption and the regurgitation of data, the fruits of human creative labor. And in these critiques, we're seeing a sort of growing sort of gesture towards copyright law as a sort of normative commitment. So basically a growing sense that ethical AI is AI that's trained on materials for which copyright permission has been sought and obtained, or responsible AI means responsible in the sense that it respects copyright ownership. And I'm concerned here that copyright lobbyists and industries are kind of co-opting the concept of responsible and ethical AI, and that AI critics are falling for it. So in this piece, what I want to do is really caution AI critics against running into what I'm calling the copyright trap, and warn them that copyright is really a false friend here. At best, I think this perceived copyright problem for AI is a diversion, maybe even a red herring. And more likely, I think, invoking copyright law in this context as a counterweight to corporate power in the AI industry is going to be incredibly counterproductive, and I think it's going to run counter to the critics' important political agenda. But before I get there, I want to put this in context a little. So AI raises, well, many copyright problems, and we can divide them into sort of two areas. So one is with regard to the inputs. So questions like, can AI be lawfully trained on copyright protected works without clearing the rights for millions, or I guess billions of texts that might be in a training data set? And then the other thing is outputs. So are AI generated works protected by copyright? Are those outputs copyrightable? And can they infringe copyright in the works that were in the training data set, perhaps? And even if they do infringe copyright, who's liable? Right? So there are lots of questions around how copyright should apply in this context. When I started working on this question back in 2018, the main focus was on AI authorship. And the concern I had was that people were talking about AIs as being creative or AIs as being authored. And so in this paper with Ian Kerr, we argue that there's no such thing as AI authorship. That authorship is inherently a communicative act, an act of social dialogue to convey meaning, an act of creative agency. And so it's something of which AIs are just categorically incapable. So because copyright requires authorship, AI-generated works, we argued, are not protected by copyright. They belong in the public domain. Then in this later piece in Ryan Abbott's book on intellectual property and AI, I tried to argue that the same kind of understanding of authorship should prevent us from regarding the training of AI as an infringing activity. That the AI is really no more an audience or an addressee of meaning than it is an author. right? So training inputs aren't really being read or received as works of expression. They're being turned into data, into statistics, into maths. And that tokenized information isn't really the expressive element of a work that copyright protects. And in any event, I argued training AI should fall within copyright's fair dealing defense for research purposes, so it shouldn't attract liability. Okay, so my position is basically no copyright in AI outputs, no copyright infringement in AI inputs. Copyright law should neither be incentivizing and rewarding the use of generative AI, and nor should it be obstructing its training and its development. This is just not the realm for copyright. Meanwhile, of course, lawmakers around the world are turning their minds to these questions of AI and copyright, and Canada was no exception. So a quick overview of what's happened here. In 2019, we had a General Copyright Act review in Canada that considered whether this process of text and data mining, AI training, would or should infringe copyright, and they concluded that we should add an exception to the Act for informational analysis to allow informational analysis or data analysis for AI. Then there was a public consultation in 2021. I got together 14 IP scholars across Canada, and we argued similarly text and data mining was lawful, not infringing. We recommended fair use should be expanded to embrace it. Nothing was done at that point. And then, of course, the rise of Chat GPT and other generative AI tools meant a sort of shift in the policy discourse, and we stopped worrying about the niceties of copyright and started to worry about the threats that AI industry might pose to the creative industries in Canada. And so there was a new consultation launched in 2023. This is kind of, if you don't like the answer you get the first time, just keep asking the question and hoping for a different answer. So the Canadian government asked again, like, what would you like us to do about this? But the whole tone of the consultation paper had changed considerably. It was now focused on questions of remuneration for copyright holders, like compensation, not whether they should be compensated, but how much. It was focused on things like, if we're going to have an exception to allow for text and data mining, what should its limits be? Should people be able to opt in or opt out? So it looks like the whole ground has shifted. The opportunity for a text and data mining exception has kind of disappeared, and Canada seems poised to follow the European route instead. In articulating the policy aims, I was concerned here that the focus was on the creative industries and the AI or technology industries. But what was lost in this articulation of Canada's copyright balance is what the Supreme Court has repeatedly said, which is that it also involves a balance between owners' rights and users' rights, encouraging the dissemination and use of works, fostering a public domain. That whole side of the balance seemed to drop out of the picture. And so I'm kind of afraid at this point about what statutory reform in Canada is going to look like coming out of these public consultations. I suspect that people are going to advocate for, and the government might be persuaded to use copyright to restrict the training of AI on the purported basis of supporting Canadian creators, but with the actual consequence, I think, of furthering the economic interests of a few market incumbents and doing little good. The other thing that's worrying me at this more abstract level is that the answers that I've provided previously are becoming increasingly unpalatable in the public debate. So there's a growing insistence that copyright is relevant here. And this comes as well from people, AI critics, whose views really are very much aligned with my own. So Kate Crawford, for example, who does fantastic work on the sort of extractive logics of AI and the environmental costs, she adds to the list of injuries the extraction of value of the works of artists and creatives on whose backs the AI systems are trained. Amanda Lewandowski here also invokes these the idea of consent, credit, and compensation. The 3 Cs are being increasingly heard in policy consultations around this issue. The 3C concept, credit, compensation, consent, actually came out of best practices for the use of Indigenous traditional knowledge and cultural expressions. And so, I argue in the paper, question the appropriateness of using this 3C concept to describe everything that every author of every Reddit post is naturally entitled to, rather than the context in which those 3 Cs were first articulated. In every other respect, I agree with these commentators. Politically, my sense is that they're on the right side of history here. They're worried about fairness and equality, about the capitalist logics undermining the social values and the public interest at stake. I just think pragmatically, they're on the wrong side of the copyright wars. Right? I think that ultimately this could undermine the political project. It could reinforce private proprietary models, exacerbate bias, and really play directly into the hands of the powers that the AI critics mean to resist. So in this context that I'm talking about the copyright trap, and I'm referring to the mistaken conviction that copyright law is the right regulatory tool to support creators and creative production in the age of AI. I think it's a trap in the sense that it aligns with the interests of a small group of powerful AI creative industry stakeholders who are perfectly happy with it, while it potentially harms the interests of more vulnerable actors who are perhaps most drawn to it. The problems of copyright restrictions on AI training are well known and articulated in the literature, but things like incomplete data sets, poor quality or limited data, which is going to produce poor quality, limited AI tools, garbage in, garbage out. Limited data can also exacerbate biases if there's reliance upon older public domain sources. Closed proprietary data sets can impede research, impede testing, transparency, limit competition, and sustain really the supremacy of today's market leaders, the open AIs of the world. Requiring rights clearance could impede then the development of competitive, inclusive, responsible, and ethical AI and serve those interests, big media, culture, tech industry, by parceling out intellectual properties, letting market logic, private ordering prevail. And then these calls for credit and consent and compensation are likely to be at best a sort of legitimizing cloak over a continued practice of commodification, alienation, and exploitation. Okay, so in the current AI debates, I identify 3 routes by which critical commentators are running into the copyright trap. With my eye on the clock, I'm not going to have time to do these properly, but let me just at least call them out for you. I think the first one is a pervasive commitment to the idea that copyright or a private property right must attach to every culturally or socially valuable thing. If value, then right. And this can lead some to conclude, for example, that AI outputs should be or must be protected by copyright, but it also undergirds the notion that anyone who reaps value from a work without permission has taken something to which they have no right. It falls into this sort of proprietary approach to copyright, supported by language like data mining technology or talk of extraction that implies that something of value is being taken away from copyright owners when AI is trained on their work. And I think that that approach, again, is being sort of co-opted and used to describe ethical AI. What we should really be thinking about when we think about ethical AI is what text and data sources should be open and available for training AI if we want to encourage its development in the public interest. The second route is the idea that the individual copy is the important thing to focus on here, that copying is an inherently wrongful act. And so every time that a copy is made, something wrong has been done that has to be corrected or that the law should intervene. And I argue here that in the context of digital copies being made behind the scenes in a way that never reaches a public audience or a recipient, to try to track these copies and to demand that permission must be sought or compensation paid for each one of these copies kind of misunderstands the nature of data in the digital era. And finally, this trope, the widely held belief or faith that private copyright control is going to hold the answer to creators' economic struggles. It is going to empower them to secure fair returns and future livelihoods against the competitive threat of generative AI. I think in this context, it just seems to be highly unlikely that given the vast number of works that we're talking about in producing AI outputs, that some sort of pro rata micro share of a license fee could possibly be the thing that's going to make a significant difference in the economic lives or well-being of artists and authors. And so there are, of course, then many good reasons to be concerned about the rise of generative AI, about the cost, the threats that it presents to creators and to the public interest. And there are important, I think, critiques to be made about the inequalities and exploitation and private profiteering that are characterizing the AI industry today. But these are also characteristics of the copyright industries that are sustained by copyright law and its myths, inequalities, biases, and exclusions that copyright is, I think, likely to make worse and not better. And so I'll just finish with this, which was a quote from Jessica Littman in her book, Digital Copyright, talking about the internet and copyright. And she observed at that time that the threat and promise of the internet has induced those of us who are copyright lawyers to an act of breathtaking hubris. We define a set of basic copyright rules of the road and then imagine that these should govern every way that information is coded and moves from one computer to another. So I think that when it comes to the threat and promise of generative AI, we should similarly caution against copyright overreaching. Copyright law just isn't equipped to make the rules for training and the development of generative AI. And I think imagining that it's up to the task could do far more harm than good. Okay, thank you.
Thank you, Professor. Thank you, Professor Craig. I just want to remind the audience that we are accepting questions. So if you do have a question for any of the panelists, please do put it into our Q&A, and we will have a session at the end to answer those. So now I'm going to pass it over to my colleague, Professor Valerio Di Stefano, who will be talking about AI and work. Valerio, the floor is yours.
Thanks again, Professor Choudhury. So I had written a presentation for this panel, and then I had to rewrite this at the beginning of this week because a series of things happened that made me completely rethink what I was going to say. One of the reasons is that I just became aware of what I think is the first decision of a labor law court about the use of Chat GPT in the workplace. And this is a decision that was issued by the Labor Court of Hamburg in Germany. And the Labor Court of Hamburg in Germany decided that there was no right of co-determination, and I will explain what that is in a second, but there was no right of co-determination for worker representatives when the employer issued a policy that allowed individual workers, if they wanted, to use their own personal account to ChatGPT to do their own work. So the employer allowed the use of ChatGPT in the workplace. It didn't invite people to use it. It didn't force people to use it. It just allowed the use of ChatGPT at work. And the Works Council, the work representatives, wanted to participate in this decision. In Germany, this might come as a surprise for many of our Canadian audience, there is a law that is there since the end of the Second World War that basically says that worker representatives have a right, and in some cases even a veto right, to participate in decisions at the business level that affect working conditions. The Labor Court said, you have this general right, and the law has just been updated to make sure that the Work Council is consulted when new technologies that surveil people, including artificial intelligence, are deployed at the workplace. So the worker representatives had a good claim that they should have been involved in the decision of allowing ChatGPT at work. And the Labor Court instead said, no, this doesn't trigger co-determination rights. Why did it do that? It probably thought that the law, the policy of the employer, by just allowing people to use ChatGPT at work, didn't impact sufficiently on working conditions and on the way people work as to trigger these co-determination rights. Now, why I am mentioning this judgment to you? Why am I boring you talking about Germany? First of all, this is what you get when you are Europeans, that they tend to talk about what happens also in Europe. That is not only the only reason. It's one of the reasons, but not the only reason. The reason I'm talking about this is actually that it allows us to break down on two important aspects of how artificial intelligence, including large language models, and generative AI, can have an impact on people at work. And the first issue I want to talk about is how AI can be used to intensify the pace at which people work. Managers, once they allow to use Chat GPT, they might be under the false impression and assumption that you are able to speed up your work extensively, and you're able to produce much more output. So basically, Chat GPT is available. You're now expected to complete your tasks much faster, in a much quicker and efficient way. Well, that is not necessarily going to be the case. As we know, and as we will be probably discussing also in the rest of the afternoon, and has been somehow mentioned by some of my colleagues before, artificial intelligence and AI software are far from being a silver bullet. In some cases, they are very good at doing what they were programmed to do, but in many other cases, especially when we want to use these systems for ends and tasks that they were not conceived for, this system hallucinate, this system create potential challenges, and this system give you false outputs, okay? So imagine you are a lawyer and you want to know what a certain case law says about any given legal institution. Well, if you go to ChatGPT, you're going to be very sorry that you did that, because ChatGPT can actually hallucinate, and we will be hearing about that probably. It can make up cases that don't exist. So if you are expected to use ChatGPT and somehow your employer thinks that you're going to be faster because you are allowed to use ChatGPT, but then you have to weed out all the fake information that any of these systems can give you back, there is no way this has a good impact on your productivity. At the same time, your employer may think that you might be more productive, and they are going to expect that you are more productive. So this is one of the reasons why I think the labor court was mistaken in Hamburg to rule out co-determination rights in the introduction of ChatGPT, because the work council, the worker representatives, could have brought a different way of looking at these things and say, well, if you are expecting people to be more productive about it, just so you know, our job is much more complicated than you probably think, and it implies a series of judgments and judgment calls that we make all the time, and you cannot expect us to be faster just because you allow us to use ChatGPT or any other such technology. So one of the things that we have to avoid, and this is where probably involving worker representatives and have a feedback from the actual people that must do the job, is, are any of these systems working? Are any of these systems good enough so that we can rely on them realistically to increase our output and productivity? If that isn't the case, this system should not be expected to increase our productivity. And again, having feedback from workers is essential in this case. Now, the other thing is that I am constantly asked, what happens if AI really allows you to do your work quicker and faster? And what is your employer is paying you the same amount of salary, and you are able to work quickly, more quickly? Well, probably it is about time that we start reap on the benefits that technology can provide us. So even if that was the case, I wouldn't see it as the end of the world. Unfortunately, I think that many employers will think that because of these systems, they will be able to automate jobs in ways that are unfettered, and this is something that we probably have to tackle at the policy level. And this allows me to bring the second issue that is prompted by the hype around AI at work. Of course, there's been a lot of discussion about how many jobs are going to be displaced by automation, how many jobs are going to be cancelled by automation. Well, of course, this is nothing new. Every time that a new technology, a new important technology comes up, there are worries, and sometimes also realistic worries about a possible job displacement of people. And artificial intelligence is nothing new in this sense. It has created the same hype that is always created when new technologies come around. AI will have probably a big potential for automatic job tasks. Now, one thing, however, that we have to consider is that automating tasks is not the same thing as automating jobs, okay? One technology can impact on jobs without deleting, without erasing, without eliminating those jobs. And if you think of the job of a lawyer, of course, the internet has made the job of a lawyer very different in the way we can access to resources and do our legal research and use electronic resources to draft our documents, etc., etc. And in some cases, it can also be argued that this has made has probably reduced the number of lawyers that are around that then are needed to do certain tasks, and that's definitely sure. But that doesn't mean that the internet has eliminated the job of a lawyer. And AI is probably going to do the same. It's going to affect the way many people work. It's not probably going to eliminate as many jobs as we think, even though there will be most likely some elimination of jobs. And the question is, what do we do about that? Now, one of the answers that we get from the AI sector, if you listen to, for instance, Sam Altman, the founder of OpenAI, is that, and he goes around saying the government should do much more to ensure that people have access to income once they're going to lose their jobs because of AI. Well, one answer that governments should probably give to Altman and his fellows is that actually it should be they that chip money to make sure that this happens in a sustainable way. It's not just the job of the government. The job of the government is to ensure that resources that are created and the productivity gains that are basically generated by technological progress are also shared in a more or less fair way around society. So yes, we should make social security system more comprehensive, more protective of people that are going to lose their jobs to automation. And we also should think about introducing forms of unconditional income support, such as universal basic income. But in order to do that, we will have to take part of the gains, take part of the productivity from the tech companies and redistribute them to society. And we should also take part of the gains that employers can make when they can automate jobs and make sure that these resources, part of these resources, are used to mitigate for the job losses, for the transition period to another job, and also to a certain extent to the provision of income that is unconditional. Again, if we are moving to a society that is more jobless than it is, probably work is not going to be, again, eliminated by technology. But if we are going to eliminate a large chunk of the work we do, we will have to survive somehow. And again, unconditional income could be a solution. But for this to be realistic, we need to get back a lot of the resources that for the moment just go upstream to the tech companies and the industry. There is also some other aspects of the impact of AI at work that are somehow neglected, much more than automation, I will have to say. And it's the way AI, and I'm not talking just about generative AI now, and algorithmic management tools are used to automate the job of managers and bosses. What I mean is that there is an increasing amount of software out there that is used to automate what were normally key functions of management. AI and other algorithmic management tools are used to hire people. They are used to monitor people. So there is software that tracks what people do with their computer all the time. They can take random screenshots of what they are doing. They may count the number of keystrokes they give to the keyboard in a certain moment of time. They can make up reports for the managers to be assessed about the productivity of certain workers. And all this not only is automating the job of, again, middle managers and managers, but also creates a series of risks that are currently neglected or grossly neglected in our societies, and particularly in North America. These systems are far from being perfect. They are far from being silver bullet. AI in hiring can discriminate against people, and particularly against the most vulnerable people in our society. We already have heard from Professor Penny. We're going to hear from the next speaker how this applies in the workplace. AI is not neutral. It can reflect the biases that are existing in our societies and the historical biases that have accompanied us so far. And so the risk is that actually we embed these biases in the technology, and the technology is going to be much more detrimental because people expect the technology to be neutral. Now, there are a number of other things that probably are going to be touched upon in the rest of the afternoon. But one thing that I want to mention is that the leading standards at the moment on these issues are the European AI Act, and we have listened from John what the problems are with the AI Act. Even though the AI Act imposes the obligation to inform worker representatives when new artificial intelligence is going to be deployed at the workplace. So this is a good thing, but again, there are many flaws in the AI Act that should be addressed. And now the Platform Work Directive that has just been approved at the EU level will also introduce a series of very important safeguards, including the involvement of worker representatives when systems are introduced that use electronic monitoring and automated decision-making on the workforce. And Canada is lagging far behind in this, and probably it should look out the other side of the Atlantic to have some inspiration about what to do when it comes to employment and labor standards. Thank you so much. Thanks again.
Good afternoon, everyone.
Oh, Ada, just give me 1 second to introduce you, and you can go ahead. So thank you very much, Professor De Stefano. And also thank you very much to everyone who is putting questions into the Q&A. We are looking forward to having a panel discussion at the end of this. Our next speaker is Ada Abraha, who will be speaking on examining AI governance in the workplace context, a comparative analysis of the workplace technology regulations in Canada, the United States, and the European Union. So it's all yours, Ada. Thank you so much.
Thank you, Bernali. Just going to set up the Good afternoon, everyone. Thank you, Professor Chaudhry and Professor De Stefano for organizing and for putting this timely conference on AI and the law. It's a privilege to be here today among so many distinguished speakers to share my paper that's work in progress titled Regulating AI Harm in the Workplace, a comparative analysis of recent legislative developments in Canada, the United States, and the European Union. My goal today is to give you an overview of the regulatory landscape related to AI regulations in the context of the workplace in Canada, the US, and the EU, highlight some key regulatory initiatives undertaken by these jurisdictions, and discuss how different regulatory models can guide the future regulation of AI technologies in the workplace. My name is Ada Abraha. By profession, I'm an employment and workplace human rights lawyer and workplace investigator with over 10 years of work experience. I'm currently on leave from my practice, pursuing a PhD degree at Osgoode Hall Law School. My dissertation examines Canadian privacy and data protection laws, emerging technologies, and their impact on the workplace. Just a quick overview of today's presentation. I will provide an overview of the research paper, how AI technologies are currently being used in the workplace, some of the risks and harms of AI that the lawyer has already noted, and of course, recent regulatory initiatives that have been undertaken in these three jurisdictions, and a consideration of what a comprehensive and adaptive regulatory framework for AI regulation in the workplace may look like. So as noted, the paper provides an overview of the regulatory landscape. It assesses, compares the scope and strength and limitations in some of these regulatory initiatives. Some of the questions that I have looked at working on this project is what are some of the key differences in approaches taken in Canada, the US, and the EU regarding AI regulations in the workplace? Who are the primary stakeholders involved in shaping workplace AI regulation in these jurisdictions? How do each of these jurisdictions define and classify AI-related risks and harms, and whether this has any implications for enforcement and compliance? And are there specific industries or sectors that are being prioritized or excluded from the AI regulations in the context of the workplace? So in terms of methods, it is a comparative analysis approach. It has involved reviewing the relevant literature, monitoring and tracking legislative developments in these 3 jurisdictions over a period of 4 years from 2020 to 2024, and creating a database. For the purpose of this research paper, it also involved creating subcategories of various regulatory initiatives. The regulatory initiative I share with you today are representatives of the type of regulatory initiatives observed in these 3 jurisdictions, but they're not as comprehensive. So if you can please keep that in mind. So the use of AI in the workplace varies, and it is being used throughout the employment cycle. We see them in the recruitment and hiring process, electronic monitoring and tracking of workers' activities, so the use of electronic monitoring and tracking for workers' activities and behaviors in real time, so in terms of their thoughts and feelings and mood. The use of algorithmic management systems for task delegation, setting quotas, measuring productivity and efficiency and performance evaluation. And we also have algorithmic bosses or automated decision-making systems that are making important employment decisions, including disciplining and terminating workers. So if we look at the global demand for workplace electronic monitoring, it has significantly increased over time. So in 2015, we see 30% of the large employers monitoring employees in non-traditional ways, so including analyzing their email texts, logging computer usage, or tracking employee movements. By 2018, this increases by 46%. By 2020, global demand for employee monitoring software increased by 108, and clearly this is directly, to some extent, as a result of the pandemic and the remote work, mandatory remote work policy. And in 2021, the global value for employee monitoring software market increased to $1.12 billion US, and this is expected to increase by 2030 to $2.1 billion and even more. So what is concerning about these technologies is that these technologies have been deployed with very little regulatory oversight. And this increased use of AI technologies has given rise to new forms of risks and harms. And unfortunately, our legislations are not up to date. And these various violations are taking place, again, with very little oversight. So in terms of risks and harms, the loss of privacy and data protection rights has been received the most attention. It is due to the excessive and intrusive forms of electronic monitoring that occurred, in particular during the pandemic, COVID-19 pandemic time. So this included sort of the continuous video surveillance. We've also seen real-time location tracking, screen capturing, monitoring of emails and social media activities, collection of biometric data like fingerprints, facial recognition data. And so there's certainly a higher risk of exposure to potential personal data abuse, for instance, selling of workers' data to data brokers. There's also the psychological stress that's caused by excessive monitoring, and of course, human rights violations, where fingerprints that are collected could also be revealing genetic disorders. So the collection of these data tend to create exposure in many different ways. However, these there are many other recent studies that show that the risks and harms of AI-powered technologies go beyond the privacy context. So we have health risks due to work intensification. We have loss of equality rights due to bias in historical data sets and proxy variables. We have loss of right to procedural due process and fairness, where the opaque and proprietary nature of algorithmic decision-making system lead to loss of right to know, the right to explanation, right to remedy, or redress the employment issues. And then, of course, we have loss of dignity and autonomy due to continuous and intrusive monitoring and delegation of task and decision-making process by algorithmic bosses, economic harms due to descaling and automation. There's also issues of time and wage theft when workers are forced to not take breaks because they have to meet certain quotas. And then, of course, we have loss of right to organize and collectively bargain due to the excessive use of electronic monitoring tools for anti-union practices. So in response to these new forms of risks and harms technologies, a considerable amount of efforts have been made to regulate these technologies. And these are underway in various jurisdictions. I've selected these three: Canada, the US, and EU, simply because these were the ones that I've been monitoring the last 4 years. So for the purpose of this paper, I adopt Julia Black's broad definition of regulation and as a process involving a sustained and focused attempt to alter the behavior of others according to defined standards or purposes, with the intention of producing a broadly identified outcome or outcomes. To help organize and analyze these various regulatory initiatives, I created the following subcategories. So we have tech-specific regulatory initiatives, regulations that focus on particular technologies in the workplace, sector industry, or specific industry-specific regulatory initiatives, comprehensive regulatory strategies for AI technologies in the workplace, both either at the federal or the provincial level, and national, regional AI and privacy and data protection regulatory initiatives that directly or indirectly refer to workers' data rights or the use of AI workplace technology, and then other forms of regulatory initiatives, for instance, AI and privacy impact assessment tools, directives, guidelines, training, and education, and also even litigation. So in Canada, we have initiatives that have taken place primarily in Ontario. We see the tech-specific regulatory initiatives bill, more recently, Bill 149, which attempts to regulate recruitment and hiring tools. Bill 88, which also attempts to regulate employee electronic monitoring. Both of them are requirement for the employer to give notice to the employee, but there are no particular recourses that an employee can take. In the sector specific, we have the Ontario Digital Platform Workers Act that confers rights and protection to digital platform workers, including right to information regarding their pay, right to minimum wage, right to notice of removal from operators' digital platform, right to resolve digital platform work-related disputes in Ontario, which are quite significant. And then Canada at this time does not have a comprehensive regulatory strategy for AI technologies in the workplace, but a report that was issued by Member of Parliament Michael Cote, The Rise of Bossware report, did recommend for a pan-Canada framework for regulating workplace digital monitoring tools. So we do also see, in terms of AI and privacy data protection at the national level, the current Bill C-27, Artificial Intelligence in Data Act, has been created to provide framework to regulate high impact, but there's no definition of what high impact is. And given the current ways and approaches that the federal government has, I don't believe that workplace tools will necessarily fall under this particular high risk, but I'm hoping that as the EU has already identified workplace tools as high risk technologies. I hope Canada will also take a lead in identifying this or in including workplace technologies as and referring to them as high risk technologies. In Quebec, the Quebec law that was recently enacted prioritizes and protects employee privacy rights while minimizing employers' liberty with surveillance technologies, and its emphasis is privacy by default. We also have other forms of regulatory initiatives. At the federal level, we have algorithmic impact assessment tools and directives on privacy impact assessment. In the US, we do see quite diverse forms of regulatory initiatives. We have tech-specific ones that are related to, again, hiring tools. In New York, it actually regulates automated employment decision tools. It's quite broad. It requires employers to conduct bias audits, automated decision-making tools, and notifies job and requirement to notify job candidates and employees in the use of assessments and evaluation to for hire and promotion. And then the state of California has also taken leads in requiring companies to disclose production quota description to their employers of their work, description to their workers, and prohibits the use of algorithm that disrupts basic worker rights, such as rest periods, bathroom breaks, and compliance with health and safety issues. We also see a comprehensive, it's just a proposal, a Stop Spying Boss Act, which has quite extensive protection for workers. The state of California already has a law that's in place called the Workplace Technology Accountability Act, which imposes various duties on employers and their vendors regarding the ability to collect and use worker data. And then, of course, we have at the national level, Algorithmic Accountability Act, the Blueprint for AI Bill of Rights, and American Data Privacy Protection Act, in which workers can actually, some of them are, the AI bill is not law yet, it's proposed, but the Algorithmic Accountability and the American Data Privacy Protections have some clause that allow workers to make claims in various ways, or protects workers' rights in various ways. And most importantly, I wanted to mention the Equality Employment Opportunity Commission has taken a very important lead in launching the Artificial Intelligence Algorithmic Fairness Initiative, provides directives, guidelines for employers, employees, and job applicants and vendors to ensure that these technologies are used fairly and consistently with federal equal opportunity laws. Finally, we have the EU. The EU has does not have a specific comprehensive regulatory strategy for AI, but there have been two important reports that have come out that discusses ways that the EU can also provide very workplace specific regulation of AI technologies, and also the trade unions have been requesting for some forms of directives specifically for the workplace. But we do have the EU Artificial Intelligence Act and the GDPR. With the EU, it does specifically state that all workplace technologies are considered as high risk. So that's very helpful in many ways. And then the General Data Protection Regulation, the GDPR, has been used to protect workers' data rights, limitations set on automated decision-making systems, and Article 40 of the GDPR, principle of co-determination, has been used by the European trade unions on workers to pursue claims related to workers' rights in terms of ensuring that workers are consulted with respect to AI systems that are used in the workplace. I'm sorry, running out of time, but my my conclusion is that I think it is important to revisit the 1944 Declaration of Philadelphia, that labor is not a commodity. We need to consider the ILO decent work framework in moving forward and develop a national strategy that coordinates and regulates the use of AI technologies in the workplace, both at the federal and state provincial level, apply the principle of co-determination or tripartite participatory approach, and recognize limitations of risk-based regulatory approaches and aim towards identifying and addressing individual and collective harms. Take a human in command approach to ensure that humans are in control of AI system in the workplace, and to consider all these different regulatory models that I shared with you today and ways that can help guide AI regulation in the workplace. Thank you very much.
Thank you very much, Ida. Okay, our last speaker then is Professor François Tanguay-Renaud, who will be speaking on contrasting police powers of detention and arrest in Canada and the United States. Is there a place for predictive AI, and some thoughts about racial profiling and its regulation? And I'm hoping that François will answer that question for us. Go ahead, François. Thank you.
Thank you, Barnali. So I'm François Tanguay-Renaud. I'm a professor of criminal law, emergency law, and a legal theorist here at Osgood. I'm also a former director of the Nathanson Center. I was in that position for 10 years. And so it's just wonderful, Barnali and Valerio, to see where you're taking the institution, really rising up to the challenges of the day. Convening this conference is simply fabulous. So thumbs up to you. So what I want to talk to you about today relates to a SSHRC Inside grant that I hold with Professor Vincent Chow at the University of Toronto and Boris Babich at the University of Hong Kong, entitled Reconceiving Procedural Justice in the Era of Artificial Intelligence. So this is just one part of the project, which I'm leading, and I'm going to try to take you into a deep dive of some aspects of Canadian criminal procedure, the space it may make for AI, and then raise the question of whether, if the space is there, whether it should be taken by AI. So to start with, 3 types of police stops in Canada are the main kinds of ways in which the police can stop and detain individuals. Arrests, investigative detention short of arrest. So the police stops a pedestrian, for example, on the street, and asks them for certain questions related to some involvement in crime that they might have had or maybe connected to. And then traffic stops, right? The police just stopping cars on the highway. Let's look a bit at the legal frameworks governing these 3 different sets of powers. So arrests, here is a paradigmatic provision for warrantless arrests. A police officer may arrest without a warrant a person who has committed an indictable offense or who, on reasonable grounds, he believes has committed or is about to commit an indictable offense. Now, that provision has been interpreted by our Supreme Court as importing two criteria. So first, the police must have subjectively held the belief that they have reasonable and probable grounds that someone has committed or is about to commit a crime before they may arrest them, form the belief based on the fact of the situation. And that belief itself needs to be reasonable. So a reasonable person placed in the position of the police officer must be able to conclude that there were indeed reasonable and probable grounds for the arrest. Investigative detention, very similar. The police must have reasonable grounds to suspect, sometimes termed as reasonable suspicion, that a prospective detainee is individually connected to a recently committed or still unfolding criminal offense, and that their detention is reasonably necessary to investigate it, right, as based on the totality of circumstances. So again, the police officer must have subjective belief based on the facts, and that belief must be backed by objectively discernible facts, which amount to this reasonable suspicion threshold, which can then be subjected to independent judicial scrutiny. Traffic stops are a little different, right? So for example, the Ontario Highway Traffic Act says that the police officer may simply require the driver of a vehicle to stop, period. Now, in a series of cases in the 80s, the Supreme Court told us, look, traffic stops in light of the highway traffic acts in various provinces need to be effected for the purpose of checking, issues related to highway traffic. So, the fact that somebody has a driver's license or insurance, that they're sober, that their vehicle is fit for being on the road. But still, right, the power doesn't say, which reasons the police officer should use to stop someone. In fact, it really enables random stops. The police can pick whatever car they want to then assess whether the driver has his license, is sober, etc. Right? So, and the court has basically upheld this power of random traffic stops. So the first question for me here, and is going to frame the project as a whole, touching upon other issues, are the legal standards in question here compatible with AI determinations as opposed to human determinations? And we focus in the project mostly on machine learning algorithms, but it could be, in the case of this presentation, just algorithms generally. When we're talking about machine learning algorithms, sort of an algorithm that is set on training data, typically historical data, for example, like, past crime data in the vicinity. The algorithm is then tasked to develop a model that can be used to estimate an outcome variable based on a set of inputs. So can produce predictions or offer a description of a given state of affair, which is then applied to new out-of-sample data that's not part of the training set, and allows then the algorithm to produce determinations, as it were. So I'm not going to go more into this. A lot of people are going to be even more knowledgeable than me in this virtual room about this, but here's the point, right? So can traffic stops be, under our current legal standards, affected by AI? Well, there's no reason why they couldn't. If police officers can stop cars randomly to check for possible highway traffic violations, that is for whatever reason, well, then the deference to the decision of an algorithm would actually meet the legal standard. There isn't any. Arrest and investigative detentions are different, though. Both powers actually require that the police officer form, remember, a subjective belief based on the facts of the situation that someone is connected to crime before they can detain them. And that belief has to be then objectively reasonable. So a police officer couldn't just defer to an algorithm for choosing who to detain or arrest. At most, one might think an algorithm could assist in ensuring the reasonableness of the police belief and suspicion. So should we then use algorithms where we can? Well, with respect to traffic stops, there's a lot of discussion about this right now. Well, for sure, it would curtail police discretion. It'd be something more to go on than basically anything goes. It could also make it more likely that stops end up revealing actual traffic offenses, right? If the machine, is trained on a lot of data that make it more likely that the police is going to be able to pinpoint cars, for example, that are unfit, right? And then more controversial, but possibly, right, if the AI becomes more accurate than individual decision-making, could reduce discrimination, pretextual stops, right? So imagine just a simple algorithm that says to the police, you must stop, or you may stop every 10th car, right? That means they can't just stop the car of black drivers, they stop every 10th car, right? Look at the Luamba decision in Quebec, a Superior Court, which tackled this decision up front, is now going up through the courts, so live action here. What about arrests and arbitrary detention and arbitrary arrests, and I meant to say here investigative detentions? Well, reasonable belief that reasonable and probable grounds are present and reasonable suspicion, they're quite vague standards. They allow for quite a lot of discretion on the part of the police. So use of algorithms here could possibly further restrict discretion, possibly even related discrimination. And it's also possible, again, caveat depending on how good the algorithm is, that it could enhance the probability of make it more likely that ultimately the objective standard is met. But notice the requirement of police officers' subjective belief, subjective suspicion, grounded in the facts of the situation, stands in the way of algorithms. Algorithms are trained and extrapolate on historical past data, not the facts of the situation. They have nothing to do with the officer's, mind processes, so they don't meet the standard. So here's the question, right? Is subjective belief or suspicion, which stands in the way of the introduction of AI decision-making here, part of the ideal of the rule of law? It seems that our Supreme Court thinks so. In a case like Castlake, they say, look, that, you know, the charter, so section 8 and 7 of our charter require that agents of the state act in accordance with the rule of law. And that means that they must not only objectively search, arrest, detain within the permissible scope, they must also turn their mind to this scope before searching. So the subjective part of the test forces the police officer to satisfy him or herself that there is a valid purpose for his or her action before it's carried out. And the Court of Appeal of Ontario has built onto that. So basically, we have a view of the rule of law here, which is a widely shared view of the rule of law, but the rule of law remains a contested ideal, which says that basically the rule of law doesn't prevail unless the law is sufficiently certain ex ante, known sufficiently in advance, and people, that is ordinary people and officials, can reasonably be expected to plan their actions in light of the law and actually seek, by and large, to follow the law, right? So Fuller, again, sorry for the typo, Joseph Raz, Scott Shapiro, all defend this view. But that's not the only view out there, right? More and more, we're talking about the rule of law as an ideal of contestation, a contestatory ideal. And under that conception of the ideal, the rule of law is really centrally concerned with constraining arbitrary and unreviewable government power by focusing not so much on ex ante guidance, but on law's ex post function in servicing as a basis for contestation and public justification. So that conception doesn't care so much about whether, you know, officials' motivations match ex ante legal criterion. What really matters is conformity to objective legal standards, insofar as this can be contested or judicially controlled ex post. What matters is whether, looking back, the officers did in fact comply with the law, not so much of whether in their head they thought they were or not, right? So by and large, Canadian courts adhere to the ex ante view under various charter provision. Section 9, actually, which deals with arbitrary detention or protection against them, requires laws that provide criteria for detention for which police officer must act if their detentions of individuals are not to be found arbitrary. But there's also some recognition of a more contestation ideal bit, right? So the Sharkawi decision, the Pearson decision, are decisions in which the Supreme Court recognized, in the context of its Section 9 case law, the importance of the availability of prompt judicial review to ensure that a detention actually complies with the legal criteria for it. So here's a provocation that I take from Aziz Huq. You might know Aziz because he's written extensively on AI, one of the leading lights in the US. He tells us the following. He says, you know, for some conceptions of the rule of law, a substitution of human for machine learning technologies likely has destabilizing implications. It sharpens the question whether the abstract concept of the rule of law needs to be realized by a particular institutional form. In fact, the question he's asking here is, well, should we, in light of technology, rethink the premises under which we came to understand the ideal of the rule of law, the dominant guidance view, right? Shouldn't we try to account for, you know, sudden technological change, take that as an opportunity to reconsider what the rule of law should entail, right? So this project takes this call to action to heart. Now, should we move away from a guidance subjective compliance? Note that our neighbors to the south have, right? So in the US, for arrest, we don't care about the subjective motivations of police officers, right? So the fact that the officer does not have the state of mind, which is hypothecated by the reasons which provide the legal justification for the officer's action, does not invalidate the action taken as long as the circumstances viewed objectively justify that action. And in fact, the infamous case that establishes that, Rand tells us, regardless of whether a police officer subjectively believes that the occupant of a car, because it's in the context of traffic stops, that case, may be engaging in some other illegal behavior, well, a traffic stop is permissible as long as a reasonable officer in the same circumstances could have stopped the car, right, for the suspected traffic violations. So possible payoffs and drawback here of use of algorithms, if indeed we move past what we hold to be the dominant conception of the rule of law in this country. Well, you might think if an algorithm is more accurate than police officers, and the kind of conscious or unconscious mental algorithms based on which in their minds they make their decisions, well, it may be that fewer innocent individuals will be detained. But then you might ask, and that's always the problem that is raised here, what about the problem of pretextual stops, racial profiling, which is often cited as the core reason for the subjective requirement, right? We want to know why the police are detaining or arresting this individual. We certainly hope it's not because of their race. The common argument here is that algorithms might actually entrench racial biases, make things worse, depending on the data on which they're trained, the inferences that they draw. The common retort tends to be, no, if we get to a point where algorithms actually discriminate less on the whole, even if they're not perfect, well, there may be a case there for them on that basis. Still, right, is a check on the actual motivations of the police when they're detaining or arresting someone, you might say, isn't that essential to stem racial profiling in policing? Our Supreme Court thinks yes, right? So the most recent take, if you have been in criminal law recently, you would have read R.V. Lay. Lay defines racial profiling, says racial profiling occurs when race or racial stereotypes about offending or dangerousness are used consciously or unconsciously to any degree in suspect selection or subject treatment. And Lee is basically doubled down and says the double structure, right, of subjective belief, which are then held to be objectively reasonable, that is key to stemming racial profiling. It says racial profiling is relevant under a Section 9, preventing arbitrary detention, because a detention based on racial profiling, so based on, right, is one that is by definition not reasonable, not based on reasonable suspicion. Our courts of appeal have ran with this. Most recently in Dudai, the Ontario Court of Appeals told us, look, racial profiling has two components, an attitudinal component. Some people accept, racial stereotypes as relevant in identifying propensity to offend or being dangerous. And there's a causation component, which requires that this race-based thinking consciously or unconsciously motivate or influence to any degree, remember the language from Lay, decisions by persons in authority in suspect selection or subject treatment. And then when there's racial profiling so defined, again, based on Lay, the Ontario Court of Appeal says there will be no reasonable suspicion or reasonable grounds. You can't detain, you can't arrest, right? Now, there are potentially quite radical implications for the justice system of this view. I think it's an overkill. They don't, and these reasons don't all have to do with AI. What do you do with the case of mixed motives, right? So think of the Ku Klux Klan police officer, a very racist police officer who notices a racialized person committing a callous murder in front of them. They arrest them because of the murder, but also because of their skin color, right? So do we want to say here that the arrest is invalid and the search incident to arrest is illegal? The police officer may then be charged for assault, evidence is excluded, etc. Seems like an overkill given the crime that was committed. There's also what it seems to me an overbroad causation component. It's less than but for causation that we're requiring here. It's influence, consciously or unconsciously, to any degree. Here's my thought. If systemic racism is a reality and unconscious racism is rampant as much as research suggests, then how many actual arrests or detentions are actually not unconsciously influenced to any degree? But here's the main issue for me in this context is the problem of proof. How does an accused go about proving that the police officer had the requisite attitudinal component and such race-based thinking actually influenced their decision, right? You might say the police might sometimes admit it, but typically they won't, and that's the thing, right? Officers likely to just keep the legal standards in mind and then tell the court whatever the court wants to hear. Lay actually recognizes this, and it's going to be even harder to demonstrate unconscious racial profiling. So the Court of Appeal of Ontario has doubled down on this and said, well, that's actually true. So we should really prove racial profiling through a totality of circumstances assessment. They say it's the role of the trial judge to consider all the circumstances that led to an accused's detention and or arrest and to determine whether they correspond to the phenomenon of racial profiling as understood in the social science literature, the reports of inquiries into racial relations with police, the case law. The trial judge can then decide whether those corresponding circumstances form a basis to infer that the record is capable of supporting a finding that the stop was based on racial profiling, even contrary to the evidence of the officer, right? So notice, whether you think there's anything ironic with this position, if you have a finding of racial profiling, if a finding of racial profiling equals a finding that the police didn't have reasonable grounds or reasonable suspicion, and if a finding of racial profiling may be made irrespective of a police officer's subjective motivations, based solely on an objective assessment of whether the totality of circumstances correspond to the phenomenon of racial profiling, as understood in the social science literature and so on and so forth, then don't we end up with something along the lines of an objective assessment of whether, all things considered, there were reasonable grounds or reasonable suspicion. So the ultimate question is, would then be, all things considered, were there reasonable grounds for the police officer to detain or arrest to be assessed by courts ex post in the context of a legal challenge? And if that's the case, and the subjective motivations of the police are not determinative, well, then deference to algorithms at the time of detention and arrest, subject to ex post facto judicial review for reasonableness, well, that becomes conceivable. And moral arguments about whether, it may actually be better, right, more accurate, more protective of liberty, and all things considered desirable, may then take center stage. So basically, a provocation to bring to the surface the two main questions that underlie my thinking in relation to this project. The more frequently asked question, so whether these new technologies we're talking about, when they're integrated into the legal system, are themselves compatible with the rule of law, right? Depending on which conception of the rule of law is deployed here, the substitution of AI decision-making can perhaps kindle some objections based on transparency, predictability, bias, procedural fairness, and so forth. But once we've addressed this, then we need to ask the second question, which is the less frequently asked, which is, rather than focusing on the compliance with the rule of law part, as it's traditionally understood, should we then use these technologies as a reason to revisit how the rule of law itself is conceived and how it's implemented? This project here is trying to really take those two questions side by side and run them throughout the fields of inquiry. It's not going to be just criminal system, it's going to be procedural system in general. So that's what I had to say. Thank you.
Okay, thank you very much. I think we do have some time now for questions. I can start by going through the Q&A, but again, if anybody has additional questions, please feel free to add it to the Q&A box. We can start with the first question, which is for Professor Hutchinson. It says, isn't one of the problems with law being interpreted by humans? The rest of the sentence does not continue. Despite the Supreme Court doing a pretty good job in many cases, the ability to succumb to biases, I believe it should be, is inconsistent with human rights, and similar is very much alive. So I think the question is,
no, I've got it.
Yeah. Okay.
I think it's about a constant thing that's made, particularly by the book that I talked about, is that we can strip out all these biases, both cognitive biases and what I'll call political biases. Of course, we don't want certain kinds of biases, but the idea that there's a place to stand which is neutral ground and will somehow be much more appropriate in deciding matters, for instance, like human rights, it strikes me as something of an illusion. Neutrality turns out to be somebody else's view from somewhere pretending to be from nowhere. And I think we need to be very aware of that. This debate has gone on in constitutional law for years. Moreover, even if somehow neutrality was possible, it would advance some interests over others. And we need to be much clearer about which interests we intend to advance and not others. So it's a relative thing. I think that Valeria said AI has a lot of built-in biases in its nature. And one is this understanding that you can actually attain a position of neutrality. And the question would be, even if we could, why would we want to? Don't we want people making human rights decisions, discrimination and the like, because we think those are bad things? So that's my response to Rohan.
All right, great. Thank you very much. Does anybody else on the panel would be interested in answering that question? Or anyone else have any thoughts? Okay, then just so that everyone can have a chance, I'll move to the second question for Karis. It says, is this not why AI ought to be regulated for ensuring good outcomes and in the public interest, as in the type of data sets used and how they are built upon, not the tech, but the outcomes in and of itself? And also, how do we ensure that technology can advance while still incentivizing innovation?
Yeah, thank you for the question. I do think it's important to stress that my suggestion is not that it should be a free-for-all and everything can be trained on anything without any limitations. My point is that copyright law should not be the thing that regulates what AI can be trained upon or not trained upon, because that's actually going to produce some unintended consequences that are going to harm the quality of the AI that we get. So yes, I think that the data should absolutely be regulated with a view to ensuring good outcomes and the public interest, looking at things like privacy and equality and restraints and guardrails on uses and deployment of AI. But there's nothing about copyright law that's going to help us do that. I think what copyright is going to do instead is allow for the kind of industry agreements that we see being negotiated between proprietary owners of big data sets, the New York Times, for example, and OpenAI, which will allow for the packaging, the commoditization, and then the sale and the transfer of enormous data sets only to those developers who are in a position to enter those licenses and to pay for them. And so the idea of the quality data set is something that's actually going to become exclusive and therefore out of the reach of AI developers because of the insertion of copyright norms as the way to regulate this. Terms of service are going to dictate that Reddit can just, package and sell all of the content that its users have created on the site. And so again, the industry interests are going to be served, but the interests of the public are not really going to be served. And meanwhile, quality data like the New York Times can't be used by other large language model developers. So I think that's the main answer. In terms of incentivizing innovation, and I think, for copyright, especially incentivizing creativity, I think that should remain the sort of prevailing concern that helps to inform policy. Like, copyright has no role in limiting the development of new technologies, especially not technologies that are used in creative practices. So I think that's it. The only thing is, I was also asked to repeat, I think, in the very next question, that concept about the AI not being an author. And so I'll just take a moment to explain again the idea that copyright is about encouraging authorship and creative exchange, not just the production of things as sort of artifacts or commodities, but really about encouraging a participatory society in a more sort of democratic sense. And so I think we have to understand authorship as that creative communicative act. That's why it's important. That's why we have a copyright system to encourage it. And that's why we don't need to harness copyright to encourage AI to generate things. That will happen anyway. And so there are other ways that we can support Canadian authors by making sure that copyright doesn't extend to AI works, by thinking more about unfair competition, certification marks, trademarks, things that will protect the sort of authenticity of human created works in the marketplace. And then maybe thinking about redirecting some funds, taxing AI developers to support cultural funds that can actually go to supporting Canadian culture and the arts, for example. It's just, again, not protecting the artifacts that are generated by AI.
Thank you, Karis. Anybody else want to respond? Okay, I'm gonna ask the next questions for Valerio, since there's a couple of questions for you. So the first was a question here about how the differences between how the courts address hallucination cases, I believe that's what it's called, both in Canada and other jurisdictions. And then there was a question also here about the platform work directive being passed last week, and what would be the impact of that on the race to govern AI. And I think why don't we start with those two, and then we come back.
Thank you. Thanks a lot, Professor Chaudhary. So yes, again, it's not that there is a unique way of reacting to court cases being made up. Normally, judges don't like when you make up cases. That is the same as if you make up cases by just using your own mind or using Chat GPT. Normally, you get in trouble if you present pleas or memos or whatever to a court and cite cases that are not existent. Probably we're going to see more of this in the future, and I expect law societies and bars around the world starting to react to this by mandating that ChatGPT or the likes are not used to produce legal content, but just used to produce drafting. Those are very different things. I use ChatGPT because I'm a non-native speaker to polish what I write. Sometimes it's much easier than just doing it with other tools, but I never rely on ChatGPT to explain to me what the law is or what cases are. These are crucial differences, and we have to make sure that people understand this. And being us in an educational environment, we'll have to make sure that our students understand that. About the platform work directive. So there's a lot of spin by platforms at the moment, trying to minimize what the platform work directive represents. The platform work directive truly represents a groundbreaking change. Of course, it is not the ideal instrument. You never have an ideal instrument. There are some flaws in the directive, but the chapter on algorithmic management, the chapter that regulates the way AI and other automated tools are used to make vital decisions on people, is really a game changer. It provides for much more rights, for transparency for workers and their representatives. It provides for a ban of the use of technologies to detect emotions and mental state of workers. It provides safeguards for collective rights, including fundamental rights to bargain collectively and strike. It provides for a ban on using automated systems to fire people or to disconnect their account. So it is a huge step forward. It is not the best instrument in the world. Again, you will never have the best instrument in the world, but it is not something that can be minimized at all.
Thank you. Other panelists, any other contributions? Okay, there was a question that was sort of directed to all of you, so maybe now is a good time to raise that. And the question was really about the transplantation of EU directives, such as the AI Act and the Platform Workplace Directive, being, I guess, applicable to other countries. And although I'll open it up to all of you, there was some references to these discussions by both Ida and John, so maybe you guys would like to sort of take the lead. And of course, Valeria, we haven't forgotten that you're European and would like to say something about European things.
Yeah, I'm happy to jump in here, and maybe just to be clear, the question is just how we understand how these provisions end up impacting us elsewhere. Yeah, sure. So I mean, often we talk about this notion of the Brussels effect, and there's other examples of this in other contexts, like the California effect in the United States, where if you're a car manufacturer and you want to sell products, you want to sell cars across the country, California has at least at the time that the term became more popular, California had the strictest emission standards. So you would manufacture your car. Obviously, it's going to be a huge market in California. So you'd manufacture your car, design your car according to California emission standards, and just sell the same car across the country. And so there'd be this California effect. So we've seen that in the context of data protection as well, the General Data Protection Regulation, because the EU is such a huge market for business and trade and commerce. And if you want to expand your business and have any European customers, then naturally it made sense that you ensure that your products and services conform to the General Data Protection Regulation. So again, it's that same idea that, well, if I'm going to be doing business with European clients or providing services, then I'm going to have to conform to this legislation. I may as well just do that for all my products and services elsewhere. And so I think there's a really good chance to see that same kind of impact of a Brussels effect when it comes to the EU AI Act. And I think we're already seeing that to an extent with Canada's Artificial Intelligence and Data Act. If you take a look at the Act, it's clearly, at least the first iterations, it's inspired by elements of the EU's AI Act, the focus on high impact AI, I think, is going to meant to correspond to high-risk AI systems in the EU AI Act. You can see that there's a concern with certain types of harms that are both sort of individual and to an extent collective, but there are, of course, differences between the two pieces of legislation. A lot in the Canadian legislation is left to regulation. Maybe that changes with later iterations of the Canada's Artificial Intelligence and Data Act. But I think you're seeing legislation and approaches across the, internationally being influenced by the Europeans' approach to this. And I think that's been a net positive to the extent that, if we were following in the past, following the American approach, they've just been doing patchwork, very weak, watered down approaches. And that includes when it comes to AI regulation. So far, it's just going to be entirely voluntary standards. There's a patchwork of state level legislation in the United States. Certainly no federal law is going to be enacted anytime soon when it comes to AI in the United States. Probably you'll see California taking the lead on privacy. We've already seen that to an extent, and likely with some state level leadership. But overall, I think it's through this kind of regulatory pressure and the nature of these systems being often online and services that are provided internationally where the European regulatory approach takes a lot of impact.
Ida, do you want to say anything? Or there is another question directed particularly to you and Valerio, if you prefer that.
Sure, I'll just, excuse me, I'll just mention about the EU AI Act, and specifically in relation, I've already mentioned it, but I would like to reiterate this because I think it's important. There are provisions within the EU AI Act that indicate that actually specifically discusses workplace algorithmic AI tools within the workplace and categorizes it under the high risk category. I think it's important in looking at C27 and moving forward to really start thinking and turning our mind to how do we ensure that workplace AI technologies are also being addressed within C27 or the AIDA. Because I think in looking at the C27, I sense that there not much attention has been given to in the context of the workplace. So that's one thing I would note, and to look at the other provisions that are also within the EU AI that specifically discusses and addresses regulating AI technologies within the workplace.
Right. There was a really interesting question here about unions and whether unions should be looking at protecting workers' rights with the introduction of AI. And in the context of that question, there was an earlier one which also talked about whether workers are in the future going to simply be responsible not for doing anything sort of productive, but really in just reviewing the work of AI. So workers will never be replaced by AI, but they will really just be taking on more of a reviewing kind of function. So maybe Valerio, we can start with you.
Of course, thanks a lot. So about the last question, I think we shouldn't make too much to distant provision in the future. We don't know how AI is going to impact on the labor market and what kind of jobs are going to be created. Yes, many of our jobs in the future will be reviewing things and outputs that are being produced electronically in a way or another, but I don't expect this to be all that we're going to do. The potential for human beings to invent new things and to invent new things to do, I think is endless, much more than the potential for AI to replace us. So I don't think we are gonna get to the point in which we will be completely displaced also in creating new things. And about unions, yes, they should definitely be more attentive and involved when AI is introduced at the workplace and demand a seat at the table before the introduction of AI or any other electronic monitoring tool at the workplace. This is what unions are there for.
Ida, any quick comments? Follow up?
Yes, I do agree with Valerio. I think it would be very important for Canadian unions to start looking at some of the very important work that's being done by the European Trade Union Confederation. That's done some remarkable work and using the GDPR of different ways of to make claims on behalf of the workers. And certainly just I think it's important to looking at I think training and education around AI literacy is very important. And in order for trade union members to be able to sort of identify some of the issues and concerns that their members may have. But part of the challenge now is that oftentimes violations do take place, but workers may not be aware of it. So trade unions may need to do some training around how these various algorithmic technologies are impacting workers on a day-to-day basis. Thank you.
Thanks. And then the final question, I'm going to raise it for both Professor Danguet-Renaud and Professor Hutchinson. So the question really was, that could we not, if we had a good AI system that really understood scientific facts, criminal law, economics, come to a better outcome? Or would there be, as another person has asked, would we just be in a situation where we have just bad data and therefore we're, which the person has said has been amassed over years of colonialism and systemic bias? Is there no possibility that we can use AI to get to a better outcome because of bad data?
Maybe I can take that very briefly. So the issue of bad data is, in my view, very important to the AI debate, but it's also not the whole story. Because even if trained on bad data, the AI comes to better conclusions, more accurate conclusions that we're more comfortable with as a society, then we have to value that for something, right? So it's true that our Supreme Court has not spoken very highly of algorithms so far. It doesn't give us much to chew on. I think the case that was mentioned is Ewert. But the point is, if AI does better, then I think we need to, run with that and see where it can actually make things better for people. Because if you ask me, what's the point of law? Ultimately, is to make people's lives better, right? And so if algorithms can contribute to that, then good. I just add that a little caveat here that my presentation simply assumes that algorithms can sometimes do things better. And the question is, if that's the case, then when does our legal system allow for that, right? And then if there are some assumptions that need to be changed, should we do this? But of course, there's this whole other question as to, what does it mean for algorithms to do things better and what constraints should be put on that? That's a very valuable question that was just not the focus of my presentation.
Professor Hutchinson?
Yeah, I can be brief. I think it's we're asking important questions. It's hard to imagine how we would respond now, but the danger is already, I think John was saying this, that we're already chasing the problem. And I think it's important we try and get out further ahead of the problem. That's going to be very difficult to do in these situations. But it's about a blend, and trying to come to the right blend will be a very difficult challenge. Interestingly, blending AI and the human, as it were, there's only one group should be able to make that decision, and that's, of course, the human side of things. We don't want the algorithm telling us what's the best mix of the algorithm and the human. So this is both, as most of these developments, is both exciting and frightening about where we can go. And I think one of my worries would be, I think that Karis emphasized this a lot, is it's hard to see any technology that we've developed that hasn't benefited and been utilized for commercial gain. And so it's naive to think that this will be the exception.
Well, on that cynical note, I would like to thank my
I don't think it's cynical, but yeah.
Thank you to all the panelists for this very enlightening talk. There were 2 other questions, I'm sorry, that we didn't get a chance to get to. Karis, if you would be so kind to answer them in the chat, they were directed at you, that would be great. Otherwise, we have a very short break before we begin again at 2:30, if I got correctly, Professor DiStefano, right? So I will leave it at that. And sorry, normally we would now use the opportunities to talk and get to know each other, but that's not going to happen. So please feel free to take a refreshment, and then we'll return again at 2:30. Thank you very much.
Thank you.